Welcome to today's episode of You and the Law. Our topic for discussion today is on rape. Were you able to read up the assignment?
Yes, ma'am. I looked it up. Section 357 of the Criminal Code defines rape as having unlawful carnal knowledge of a woman or girl, without her consent, or with her consent, if the consent is obtained by force, or by means of threat, or intimidation of any kind.
Okay. That is enough. What else is also spectacular about Section 357?
From the section, it appears that the offense of rape can only be committed against women.
That is correct. Even though we understand that men can also be raped.
There is also the issue of consent. The unlawful carnal knowledge must happen without the consent of the woman or girl in question. If she gives her consent, then it is not rape.
You are partially correct. A minor, or underage female, is incapable of giving consent. Therefore, it is still rape even if she consents.
Other persons who are incapable of giving consent include persons mentally incapacitated, persons under the influence of alcohol or drugs. Others include vulnerable adults and unconscious persons.
These group of persons are incapable of giving consent. Sexual intercourse with these group of persons will be considered rape. However, if the person is one capable of giving consent, and there is proof that she consented to the sexual intercourse, the charge of rape will fail. In ICO versus the State, 2001, 4 NWLR, Part 733, 221, the court stated that the consent of the victim is a complete defense to the offense of rape.
Thank you, Ma, for that explanation. I have another question. How can you prove the offense of rape in court?
Our case study today will answer that. You will see it play out in court.
Okay, Ma. I am looking forward to it.
Again, and very important, we will also be looking at the role of the government and ensuring that our young girls and daughters are protected. For example, how do we explain that a young school student was raped because she left her classroom and entered the bush to defecate? How? It makes no sense. Government must ensure that these basic things are available and then maintain them properly. You cannot build toilet and not provide water. In some schools where you have toilets, there is no water. How will these students even use the toilets if there is no water? Government must rise and begin to do the needful. Government, both at the federal and state levels, have a responsibility to ensure that all Nigerians, especially the young, are protected and cared for. The Supreme Court had cause to admonish the government in Kazeem Popoola versus the State, when a young school student was raped. Let us now go to the court to watch the full story.
The story you are about to watch happened on January 29, 2004 in Abeokuta, Ogun State, Nigeria.
At least, let me rest now. Today has been a hectic day. This is the fourth time you are farting today. What is wrong with you? My stomach is paining me. I need to use the toilet. Sorry, my sister. That means you will be entering the school farm. What is the problem, Adesua? Please, Ma, I would like to ease myself. Okay, go quickly. Thank you.
She ran quickly to the bush to ease herself. She had just finished doing her business when a man approached her.
I feel better now. Who is that?
Stop there, student.
Good afternoon, sir.
So you are one of the students messing this place up? We have warned you students to stop using this place as toilet.
I am sorry, sir. It will not happen again. I had no other choice.
How much do you have? Bring it or I report you to your head teacher.
I do not have money, sir. Please forgive me.
Kazeem dragged Adesua to the bush and had carnal knowledge of her. After that, he disappeared from the scene.
Please, Ma. You need to come. Something is wrong with Adesua. Oh my God. Where is she? She is outside, Ma. Please come quickly.
The teacher saw Adesua sitting outside with blood all over her uniform. She reported the incident to the head teacher, who closed down the school temporarily and took the girl to the hospital. The matter was also reported at the police station. The police combed the entire area, but did not see Kazeem, the alleged rapist. He had absconded. The police searched, and searched and searched. He could not be located. Then one day, on the 24th of July, 2004, 6 months after the incident, Adesua was on her way to the market when she saw something.
I have seen that face before. I have seen that man before. Yes. I remember. I remember. The idiot that raped me. This man will not escape today. I will make sure of it.
She immediately placed a call to her mom, informing her she just saw the man that unlawfully had carnal knowledge of her. Her mom called the police station and informed them. Adesua was advised to continue to follow him without being noticed. She did.
I hope they get here on time. This man must pay for what he did to me.
She continued to lurk around the man until the police came and arrested him. He was thereafter taken to the police station. At the police station, he made a confessional statement admitting the offense of having unlawful carnal knowledge of Adesua. On December 15, 2005, he was arraigned at the State High Court on a charge of rape contrary to Section 357 and punishable under Section 358 of the Criminal Code laws of Ogun State.
Call the first case.
Kazeem Popoola versus the State, 2013, 17 NWLR, Part 1382, SC. My lord, the accused person is in court.
Any legal representation?
May it please my lord, I am Bassie West. My appearance is for the prosecution. May it please my noble lord, my name is Jude Johnson. I am appearing for the accused person.
Read the charge to the accused person.
Kazeem Popoola, you are standing trial for the offense of rape, contrary to Section 357 and punishable under Section 358 of the Criminal Code laws of Ogun State. Guilty or not guilty?
Not guilty.
Call the first witness.
As the court pleases. Miss Adesua, please tell the court what happened in your school on January 24, 2004.
On that day, I had gone close to the school farm to defecate. I had just finished defecating when the accused accosted me. He said he was going to report me to the school authorities because I defecated on the school farm. He said if I gave him money, he would forgive me. I begged him that I had no money. Before I knew what was happening, he slapped me, pushed me into the bush, and forcefully had sexual intercourse with me.
What happened thereafter?
He ran away after. I went into the class to report to my teacher. My teacher reported to the head teacher, who took me to the hospital.
Have you ever met him before that day?
I have never met him in my life.
So, what did you do when he grabbed you?
I screamed. I shouted. I struggled with him, but he overpowered me.
That will be all, my lord.
Any cross-examination?
As the court pleases. Adesua, I learned your school barred everyone from defecating anywhere in the area. Reason being that to protect you students from wanderers. Why then did you go there to defecate?
I was so pressed. There was no other place I could use.
When the accused approached you, did you not notice that he was not coherent? Did he not behave like a person who is sick?
He was coherent. He knew what he was doing.
That will be all for the witness, my lord.
Call your next witness, counsel.
As the court pleases. Please tell the court who you are. My name is Felix Daniel. I am the investigative police officer assigned to this case. We did the initial investigation at the scene the purported rape took place. What were your discoveries? We first noticed that the grass around that area was ruffled and bent, which showed that there was a struggle in that place. We also saw footprints, belonging to an adult and that of a student. We took pictures of same. The pictures were admitted in evidence, unmarked Exhibit B and C. So, how did you arrest the accused? How were you able to link him to the crime? After our initial investigation, we searched everywhere with the description the prosecutrix gave us, but we could not locate him. It was some months after the incident took place that we received a call from the mother of the prosecutrix, informing us that the prosecutrix sighted the accused somewhere around Mortuary Junction. We mobilized immediately and arrested him there. We took him to the station where he made a statement admitting that he actually raped the prosecutrix. The extrajudicial statement of the accused was admitted in evidence and marked Exhibit D. That will be all, my lord. My lord, the prosecution will be closing its case at this juncture.
Open your case, Mr. Johnson.
As the court pleases. Mr. Kazeem, can you tell the court what happened on January 24, 2004?
On that day, I was sitting down in the bush when I saw someone defecating. I stood up to find out the person, and when I saw that it was a student, I didn't know what came over me and I raped her.
What do you mean by you didn't know what came over you?
It is mental sickness, sir. I have been suffering from mental sickness. The sickness overwhelmed me, sir. I didn't know what I was doing.
That will be all for this witness, my lord.
Any cross-examination?
Mr. Kazeem, from your evidence in chief, you testified that you have mental sickness. Am I correct?
Yes, sir. I have mental sickness.
You also agree that you had unlawful carnal knowledge of the victim, but the reason was because of your mental instability. Do you remember everything that happened on that fateful day?
Yes, sir. I remember it.
Please tell the court.
On the 25th of January 2004, at about 11:30 hours or thereabout, I was at one prayer house behind Abiyakuta Secondary School, when something told me to enter the nearby bush. When I went to the bush, I met a student who came to defecate. I held a girl and dragged her away from nearby people into the bush. I forced her, pulled her pant, she dragged with me, she poured me sand on my face. I beat her and assaulted her by giving her fist blow which made her weak. I unlawfully had a carnal knowledge of her. I did not tear her pant. I do not know what pushed me to the bush.
That will be all, my lord. That was how the supposedly mentally deranged Kazeem told the court what happened.
Call your next witness, please.
As the court pleases. Please tell the court who you are.
My name is Bint Aisha. The accused is my brother.
Is there anything you would want to tell the court about your brother?
Yes, sir. My brother has been sick.
What is the nature of his sickness?
Mental sickness. He has not been behaving normal. He is mentally insane.
What did your family do about his insanity?
He has been in a prayer house. It was when I went to the prayer house that I learned he had escaped from there.
That will be all, my lord.
Any cross-examination?
No, my lord.
Call your next witness.
As the court pleases. Please tell the court who you are.
I am Prophetess Dimka. I heal different kinds of mental illnesses and diseases.
Do you know the accused person?
Yes, I know him. He has received prayers in my ministry in the past.
That will be all, my lord.
Any cross-examination?
Yes, my lord. Madam, from your evidence here in court, you take care of mentally deranged people?
My ministry provides accommodation for them. We pray for them and feed them until they get better.
So, what do you do when they get better?
Once they get better, we examine them thoroughly and then discharge them.
So, how come the accused was found wandering outside when he was still receiving treatment?
The accused had long been discharged, sir. We discharged him when he exhibited sanity in the ministry.
That would be all, my lord.
Address the court counsel.
My lord, from the evidence before the court, there is no doubt that the prosecutrix was raped by the accused. The accused admitted it. However, my lord, the defense that he is mentally insane cannot be sustained. A person who suffers from insanity cannot be as coherent as the accused. He merely raised the defense of insanity without discharging the onus placed on him by law. My lord, I pray the court to convict the accused person based on the evidence before the court.
Counsel for the accused, please address the court.
May I respectfully refer, my lord, to Section 28 of the Criminal Code Law of Vogan State. It provides as follows. A person is not criminally responsible for an act or omission if at the time of doing the act or omission he is in such a state of mental disease or natural mental infirmity as to deprive him of capacity to know that he ought not to do the act or make the omission. My lord, a careful look at this provision shows that because of the mental sickness of the accused, he cannot be held liable for the offense for which he committed. I pray my lord to discharge and acquit the accused, based on Section 28 of the Criminal Code Law of Vogan State. After the argument of counsel, the court delivered its judgment.
I have given serious consideration to the evidence before the court, and I am of the settled view that it will be perverse for me to hold that the accused person was, as at the 29th of January 2004, suffering from any mental disease or infirmity. Evidence before the court shows that the accused person, as at the 21st of December 2003, had sufficiently recovered from whatever it was that he was passing through. The confessional statement he made was admitted without objection. I find him guilty as charged and sentence him to 5 years imprisonment with hard labor.
Dissatisfied with the judgment of the High Court, Kazeem appealed to the Court of Appeal. The Court of Appeal dismissed his appeal. He made a further appeal to the Supreme Court. Issues canvassed at the Supreme Court were 1. Whether the confessional statement of the appellant, in view of his defense of insanity, is a corroboration of the sexual offense of rape. 2. Whether the failure of the trial court to comply with the provisions of Section 223 and 224 of the criminal procedure laws of Ogun State to determine the insanity of the appellant at the trial prejudiced the trial of the appellant. 3. He also argued that no medical report was presented to show that Adesua was actually raped. In a well-reasoned judgment, the Supreme Court held, in a charge of rape, the prosecution, among other ingredients, is required to prove that the appellant had carnal knowledge of the prosecutrix and that it was without her consent. The appellant, in the instant case, admitted having carnal knowledge of the prosecutrix without her consent. The issue is whether at the time the crime was committed, the accused was mentally unsound, for which it can be said that he is not responsible for his act. The law still remains that the onus of establishing insanity is on the person alleging insanity. In this case, Mr. Kazeem. No evidence was adduced by the defense as to his hospitalization at any point in time. Nothing was also said of medical consultation. One of the witnesses even said he had gotten better before he left the ministry. The statement he made were clear, lucid, and did not show the statement of one with unsound mind. On the issue of medical report, the requirement that medical report is mandatory is only relevant if there was denial of the offense by the accused. This is not the case in this case, as the accused admitted having sexual intercourse with the prosecutrix. What is required is that once denial is at play, the court is encouraged to look for a medical report showing injury to the private part of the victim. In the case at hand, even though that there was no medical report, there is a confessional statement that is direct, cogent, positive, and in fact, lends strong support to the evidence of the victim. The submission that the confessional statement be disregarded, because the rapist was insane at the time, is a flying kite without purpose. The insanity defense has effectively been debunked, and unsupported by any evidence worth its salt. I cannot fail to express my disappointment, however, on the lenient terms of imprisonment of 5 years dished out by the trial court. Since it was not appealed against, sadly, it will remain in a heinous crime such as this. Government must make sure that toilets are made available for school children. The victim would not have been exposed to this heinous crime if she had stayed in her school toilet to defecate. The appeal has no merit and is hereby dismissed.
Welcome back.
Thank you, Ma. However, I am confused. By the provisions of Section 358 of the Criminal Code Laws of Ogun State, the punishment for the offense of rape is life imprisonment. Why did the High Court dish only 5 years imprisonment?
I do not have an idea.
So, why did the Supreme Court not change that?
That is because the prosecution did not appeal against it. Remember, the court is not Father Christmas. It cannot give you what you did not ask for.
And he had the gut to claim insanity.
So annoying.
I hope you enjoyed this episode. Any form of crime diminishes a nation. Please desist from it. Please do not forget to subscribe to my channel. Bye. See you soon.